Hello, this is Alicia Sam and you're watching HW News. The Supreme Court of the US on Friday this week struck down the ultimate prevailing shields of the federal abortion rights. The Roe v. Wade ruling, first constituted in 1973. On Friday this week, the Supreme Court, in a 5-4 decision, overruled the Roe Court ruling giving states individual autonomy to consider their abortion regulations. Almost half of the states are expected to prohibit or limit abortions as a result of this decision. The Roe v. Wade 1973 hearing that ruled unduly restrictive states' regulation of abortion as illegal in response to a set of Texas statutes criminalizing abortion argued that its regulation in most instances hindered a woman's constitutional right to privacy. The right-wing majority of the U.S. Supreme Court, in 5-4 ruling in the Dobbs versus Jackson Women's Health Organization case on Friday, asserted in a majority opinion by Justice Samuel Alito that the Constitution makes no reference to abortion and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely. The Due Process Clause of the 14th Amendment. Roe overruled several statutes of courts at a time when nearly all states outlawed abortion, excluding conditions of life at risk, rape, incest, and fetal anomaly. While liberal states have offered to maintain a lenient position on the termination of pregnancies, almost half the states in the nation will push for the polar opposite. The US witnessed a huge gathering at the Supreme Court decision to appeal. The decision has set the nation on fire, as this will restrict millions from quality healthcare around the country who may have to travel across states to find help. Let's take a brief history of the Roe v. Wade debate. The Roe v. Wade case commenced when plaintiff Norma McCorvey, under the pseudonym Jane Roe, instituted federal action against Wade attorney Henry Wade. Roe's attorneys Sarah Weddington and Linda Coffey proceeded to file a lawsuit in the U.S. federal court as the court rejected Roe's assertion of an absolute right to pregnancy. Roe, who in 1969 became pregnant with her third child, sought an abortion, which was illegal in the state of Texas unless under the count of rape, incest, or threat to life. Roe's team challenged Texas abortion regulation, citing that they were unconstitutional. The state rebutted her claims, saying that to terminate the pregnancy at any time and any way cannot be fulfilled, and it would overreach the state's authority to balance a woman's right to privacy with states' interest in regulating abortion. The Supreme Court head Blackmun opined to the case that only a compelling state interest justifies regulations limiting fundamental rights such as privacy, and added that legislators must therefore construct statutes narrowly to express only the legitimate state interest at stake. The Texas statute was then asked to balance its distinct, compelling interests in the area of the health of pregnant women and the life of the fetus. The Supreme Court concluded that it would curb the state's compelling interests to only regulate abortions at the end of the first trimester. The courts regarded the life of the fetus as follows: capability of meaningful life outside the mother's womb, or viability, which occurs only at about 24 weeks of pregnancy. In the case of Roe v. Wade, the Supreme Court concluded that the women's right to form decision freely about the termination of a pregnancy deserves the maximum level of constitutional defense. The court also acknowledged the idea that the right to privacy is not absolute and that the state may, but it is not required, to prohibit abortion after viability. Finally, on January 22, 1973, the Supreme Court of the US issued a 7-2 decision stating that the Due Process Clause of the 14th Amendment to the United States Constitution provides a fundamental right to privacy, which in turn will serve to protect the highest defense to the choice of women on the case of terminating or not terminating her pregnancy. For decades, pro-life politicians and activists fought to overturn the judgment. Although Planned Parenthood versus Casey overturned Roe's trimester framework and dropped Roe's strict scrutiny requirement in favor of a more flexible undue burden test, the Supreme Court reiterated its central holding in that case. Roe versus Wade was abolished. Was Donald Trump the X factor for the same? The landmark decision constituted by the Supreme Court on Friday to a great extent reverberates the historical single-term tenure of President Donald Trump. Through the slam of Roe versus Wade, the Trump has successfully delivered what he promised to his core right-leaning constituencies full of evangelical Christians and anti-abortion Republicans. Trump, who commented about the decision as an act of God, claimed in his statement early, "Only made possible because I delivered everything as promised." But how does yesterday's president influence today's choices? To understand how Trump played an important role in this decision, we must look back at an abolished abortion law in 2018. Dobbs versus Jackson Women's Health Organization is a case about the Mississippi state law that illegitimate abortions after the first 15 weeks of pregnancy. The case became the vehicle to overturn the Roe ruling when lower courts from the state prevented the immediate employment of the law through preliminary injunctions based on ruling from Parenthood versus Casey. The ruling preventing states from banning abortion before viability and promised constitutional protection to the women whose rights are in check via the right to privacy under the 14th Amendment to the U.S. Constitution. The Dobbs versus Jackson Women's Health Organization took the complete position of an ideological vehicle used by the conservative Trump authority to overturn Roe rulings. The nail for the coffin took form when Donald Trump nominated Amy Coney Barrett as an associate judge to the Supreme Court to fill Ruth Bader Ginsburg's position. Bennett is an outspoken pro-life advocate coupled with Trump's favorites Brett Kavanaugh and Neil Gorsuch. The mechanical move to appoint the three conservative judges arrived as planned attack to flank the Roe rulings. Trump appointed Barrett just a week before the 2020 elections, which he initially lost. Kavanaugh's nomination ran into serious troubles on allegations of sexual assault, the investigation of which was never followed through alighting a narrow confirmation by the state. While Gorsuch's nomination came in 2017 when minority Republican leader Mitch McConnell refused to conduct a confirmation hearing on Barack Obama's pick for the Supreme Court, followed by the death of Justice Antonin Scalia. The Justice Committee that supported overturning the Roe rulings included conservative Republican judges Samuel Alito, Clarence Thomas, John Roberts, Brett Kavanaugh, Neil Gorsuch, and Amy Coney Barrett. Let's understand what is the position on law abortion in India. India's Medical Termination for Pregnancy Act 1971 allows abortion until 20 weeks of pregnancy. Through an amendment in 2021, the ceiling for abortion was raised to 24 weeks, but only for special categories of pregnant women such as rape or incest survivors, that too with the approval of 2 registered doctors. In the case of fetal disability, there is no limit to the timeline for abortion, but that is allowed by a medical board of specialist doctors set up by the government of states and union territories. In approximately 16 countries around the world, abortion is entirely prohibited and even criminalized. But several Catholic majority nations such as Ireland and Mexico have decriminalized abortion in the last decade. That's all for the report. To watch such contents, subscribe to our channel and do let us know about your views on this topic in the comment section below. Take care of yourselves. Thank you.